Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, Principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Well, first of all, thank you, Lindsay and Joel, for joining me. We've got a biggie today.
We do.
We do. Well, today we're gathered to talk about the May 22nd, 2026 Adjustment of Status Policy Memo that provided examiners with additional guidance on adjudication of adjustment of status applications. And for a policy update that purports to merely restate existing law, not change anything, and merely provide guidance based on existing law to examiners, this really has been a ground shaker, as I think everybody tuning in knows. And we certainly know from the flood of questions and concerns our clients have expressed to us based on this memo. So what we're going to do today is go over some top 10 most commonly asked questions that we've been fielding. And we're going to share our approach to these questions based on the May 22nd policy memo. Now, what we're sharing is not case specific. It's certainly not advice. And it's based on our current reflections as we absorb this guidance. And so no doubt these reflections will evolve and change, particularly as we see the most important thing in all of this, which is how USCIS will actually implement, operationalize this guidance. And we won't know that until we see actual 485 adjudications that apply this guidance. So what is clear is that we have heightened risk on adjustments of status across the board. And why? It's because this memo makes clear that adjustments of status are not benefits as of right. They are discretionary. And moreover, the language that's caused so much concern in this memo is that it talks about adjustment as extraordinary relief that examiners should only confer as an exercise of administrative grace. So there's a lot of language in here that really speaks to a tone change that really could be a sea change in how adjustment of status applications that we'll also call AOS will be decided in the coming weeks, perhaps months. We will have to see and pay very, very close attention. There are no absolute do's and don'ts that have emerged, again, because we haven't yet seen this guidance be operationalized. So that said, there are a few principles that we think have emerged, and we're going to try to share those with you in the course of this webcast today. And again, finally, because this is so important and so emerging, evolving, yet topical, I want to emphasize that this is not advice in any way, nor does this create attorney-client relationship with anyone. That's only created by a signed engagement that formalizes the relationship between attorney and client. All right, so with that, let's get into this. First question, can I still file adjustment of status applications? All right, so for fear of hogging airtime, I'm going to take this one. All right, so the answer is yes, if the applicant is still eligible under INA 245 and implementing guidance. And it's important because the concerns have risen to this level. Can I file adjustment of status at all? The May 22 memo provides guidance, reminder, first of all, that adjustments are discretionary, suggesting, the default, as the memo says, should not be the AOS is granted, but that it's consular processing that's the default process. Therefore, adjustment grants should be deemed extraordinary. But it does not eliminate adjustment of status application eligibility at all. Okay, so that's clear. Question 2. Does the memo eliminate EB-5 concurrent filing? So I'll just take a moment to say, while this tone change, sea change is vast and covers all adjustments, we're here to talk about how it affects EB-5 investors specifically. So we have concurrent adjustment under the RIA. Does this eliminate concurrent adjustment of status for EB-5 investors? The answer is no. Again, 245, the statutory authority for the grant of adjustments is not revoked. It is not modified. The statute is not changed. And moreover, the RIA specifically adds a section in the RIA that allows for concurrent adjustment of status for EB-5 petitions. So none of that is changed. The statutory framework is not changed by this memo. However, why is this memo so concerning? It's because it sets out these discretionary factors. Discretionary means case by case. It also means quite possibly subjective. And that means that we have a lot of uncertainty as to whether an application, an adjustment of status application, will be approved or denied. I think it's helpful to go down some of these discretionary factors. The memo talks about the discretionary factors and the examiner looking to a totality of the circumstances, the good and the bad, the favorable and the unfavorable. So what are some of the unfavorable factors? Violations of our immigration laws. Conditions of any immigration status held, violations of those. Current or previous instances of fraud or false testimony in dealings with USCIS or any governmental agency. Now, there's also our grounds of inadmissibility, right, under separate statutory framework. So all of those also remain in place. Whether an alien's application for admission or parole violated the laws, regulations, or policies in place at the time. So if there's later an exculpatory change in law or policy, that can still be outweighed by this negative factor. And any conduct of the alien after admission as a non-immigrant or parolee inconsistent with the purpose of that non-immigrant status or parole, inconsistent with the original purpose. Representations made to a consular or DHS officer when applying for a visa, admission, or parole at encounter with CBP or pre-flight inspection. An alien's failure to comply with the conditions of their non-immigrant admission or parole. An alien's failure to timely depart. So those, if there are any of those are negative factors in that side of the, what is that? The scale. Best interests of the United States must be considered by the examiner, which I think there's our opportunity to elevate some positive factors, including family ties, which can be both positive and negative, depending potentially on the purpose of your visit, the permitted purpose of the visit. Immigration status and history. Yes, I've done everything right all the time. The applicant's moral character. Now, this is one of these open-ended things that could be used as a favorable factor and also as an unfavorable factor. and any other relevant factor that bears in determining whether the alien warrants favorable exercise of discretion. So some of those feel kind of robust enough and others feel quite open-ended. All right. Lindsay, if an applicant files AOS, does the applicant need to maintain underlying non-immigrant status?
Well, our advice for quite some time now has always been that maintaining a valid underlying non-immigrant status is strongly advisable. It allows the foreign national to have something to fall back on if the adjustment of status were denied. But it also weighs into that scale that you were just talking about, balancing the factors, having maintained an underlying non-immigrant status weighs favorably on that scale for granting the adjustment of status. And we're not too certain yet how heavily it will weigh on the scale if someone has not maintained their underlying non-immigrant status. So I think it's especially important that people think about their underlying non-immigrant status, maintain it as much as practically possible for their life, their work, their travel, their family. And for clients in F1, even those who have OPT, H1B, L1, the safer interim guidance is to not allow that status to lapse if possible. And to try to avoid relying solely on the AOS, the adjustment of status based benefits like an EAD, work authorization, or advanced parole for travel. But you need to speak with your immigration team to figure out what makes the most sense for you. And we're still figuring out how all of these factors are going to balance ultimately in the decisions. But the safest option in answer to that question is to try to maintain an underlying non-immigrant status, I think.
Yeah, yeah. And it's certainly easier generally for H's and L's than other statuses, particularly since dual intent is recognized. But the memo says it doesn't mean you're out of the woods just because dual intent is recognized and you're an H or L. Okay, so fourth question. Are B1, B2 visitors allowed to file AOS right now? Joel, what do you think?
Yeah, so I mean, the memo doesn't is not clear one way or the other. It's still just giving guidance and policy reviews. So, per the memo, a B1, B2 visitor can file an AOS. But this is certainly an area where we probably expect to see some of this discretion come into place. This is certainly the higher risk, if not the highest risk type of mechanism to file the AOS.
Yeah, I think so. I really do. Recall the factors, again, it's the purpose of the visit, not overstaying. And certainly we have had clients who have come in as visitors to go to Disney World, quite literally. They left the water running back home and just came and talked to us, and we're talking about the potential backlog and all these other things, and they became persuaded themselves that they really that this is the right decision for them to go for adjustment of status. They came in as visitors, they've done everything correctly, they had the correct intent when they came in. And so certainly, and 245 says if you were admitted, inspected, and you're not barred under the bars under the statute, failure to maintain status, unauthorized work, et cetera, we won't get into those exceptions, but done all of those things correctly, then this memo shouldn't bar adjustments in that instance. It's the preconceived intent. It's those visitors who may not be able to show that they came in solely for the purpose and did not overstay, who may have difficulties satisfying the standards under this memo down the road. Yeah. What happens, Lindsay, to an applicant's pending AOS application under this memo? Are there any changes to that situation?
Well, they remain pending and will continue to process. They will be reviewed by the USCIS examiner with this new policy memo in mind. But again, they're going to proceed as they have been. We don't know yet whether we're going to see faster adjudications or slower adjudications, or if that will impact this at all. So at the moment, if you've filed an I-485, your adjustment is pending, and you'll wait to hear from USCIS on any updates on the processing of your case. EAD cards and advanced parole documents will continue to be processed in the same way as well. Whether you decide to travel and work on those ancillary benefits depends on your decision on how to and whether you're going to maintain your underlying non-immigrant status. And different non-immigrant statuses have different levels sort of dual intent. H&L, it's very clear, and people would be able to extend those statuses and maintain those statuses. And you'll have to speak with your non-immigrant visa attorney about whether you can do that for other underlying non-immigrant statuses to try to help maintain that. But it is very important, if you want to maintain your adjustment to be pending, that you not travel without the appropriate permissions, or you risk abandoning your adjustment of status application. So, for instance, if you are in F1, you need an advanced parole approved in advance of traveling, otherwise you will abandon your adjustment of status application. That's different for H's and L's, but it's true for other non-immigrant visa holders, and so people need to be aware of that.
Yeah, and Lindsay, that's a very important point. And what about coming back? Suppose that F1 student didn't leave until he or she had the advanced parole, but still has got that valid F1 visa that's not been canceled.
Sorry, you said if they leave with
they leave with the advanced parole, so they haven't.
If they have that advanced parole when you leave, it's very important you present it when you return, and that you not return on your F1 visa, because if you return on your F1 visa, you have abandoned your adjustment of status application.
Yeah.
Yep.
Very, very important.
Very important.
All right. So, Joel, what happens if an applicant's 485 is denied?
Yeah, so I mean, it goes back a little bit to what first instance, what Lindsay was saying. I mean, obviously, this is if you have an underlying non-immigrant status, you're okay, and you don't have to worry about it as long as that continues to be valid. I mean, obviously, you have the denial, but at least you're still not accruing unlawful presence. Without the underlying non-immigrant status, you're immediately accruing unlawful presence in the United States, and the proceedings can start as far as, getting a notice to appear and having removal proceedings. So, certainly the recommendation is to immediately start getting your affairs in order and leaving the United States so that you can maintain, not accrue unlawful status and maintain as strong a position as possible for future applications, whether they're immigrant applications or non-immigrant applications, to come back into the United States. Yeah,
exactly. And for me, when I think about the memo and the potential consequences, it's almost like there's this sort of conflict, because on the one hand, yes, we have the statute, we have the adjustment of status is not eliminated, and at the same time, we have these open discretionary factors, and if the application is denied, the consequences can be so dire, including, as you mentioned, Joel, unlawful presence, needing to wrap up your life very quickly that can be traumatic. And also potentially impacts on a future non-immigrant visa application. Your subsequent B renewal application, or even potentially your immigrant visa application down the road. We don't know. So this is why we're so concerned.
I should add there are options at times to make a motion to reconsider or reopen if there were mistakes, and if there are new facts or there was a mistake in the law. There's a 30-day deadline for that, but obviously that hasn't changed in the context of this memo, and any sort of discretionary denials in the context of this memo are unlikely to sort of trigger those motions.
Right. That's great. You do formally get another bite through that process. Should I switch to consular processing right now? And I'll take that. And the answer is maybe in certain cases. Do I think this is the time to wholesale try to switch to consular processing? Not persuaded of that yet. Although I think it is clear as anything can be at this moment, that having the ability to pursue both tracks is advantageous. Maybe now more advantageous than ever before. Note though that to do that, if your petition was not set up for consular processing, the applicant would need to wait until that petition is approved, the 526E is approved, and then can file an I-824 application to notify the consulate of the approval and trigger the National Visa Center process. So I think it's good to know that process is there. It's not the most streamlined. There's no premium processing for 824s, et cetera. But that process is there. Lindsay, can I still use my interim benefits if I'm an AOS applicant, such as EAD and advanced parole, safely?
Yes, I mean, you can, but it goes back to the discussion that we've been having, and that I've mostly been talking on this webinar about whether you're going to maintain your underlying non-immigrant status. So we urge caution. If you decide to use the work authorization and travel authorization that come with your pending adjustment from an EAD or advanced parole, using them will have consequences on your current non-immigrant status and your overall immigration strategy for obtaining your green card. So if you use those to work or travel, then you are giving up your underlying non-immigrant status. You are still in lawful stay in the United States by having the pending adjustment, but as Joel was describing, as soon as an adjustment were to be denied, you would lose that lawful stay. And so you would have given up having the non-immigrant underlying status. There's increased exposure if your adjustment is later denied. You should consult with your non-immigrant visa attorney or your adjustment attorney to discuss whether using that work and travel authorization makes sense, or if just having it in the background is a safety measure in case, unfortunately, you would lose your H-1B job and need work authorization, or an emergency happened in your family and you needed to travel. Then you would weigh the circumstances and make that decision. But our best advice at this time is to try to maintain that underlying non-immigrant status and not use those if you can avoid it.
Yep. All right. Okay. So we're going to try to cover this quickly. And Lindsay, you've already touched on some of these considerations already. How does the memo affect specific visa categories? Specifically, let's try to touch on the F1 student, H1B and L1s, and visitors, B1, B2
Okay.
visa holders.
Sure. So we'll start with students. Maintaining that F1 or OPT compliance to the fullest extent is important because of denial risk concerns. Also, abandonment. You don't want to travel after your advanced parole issues and re-enter with the F1 as we discussed earlier. So you have to consider whether you want to use work and travel authorization or if you want to try to maintain that F1 OPT status. H's and L's are in a different situation. Because of dual intent, these categories have an easier time maintaining their status. They can work and travel on that H or L while still maintaining the adjustment of status application and not abandoning it. So individual factors are still going to matter in this case, particularly if there have been prior U.S. immigration violations or breaches in law in any jurisdiction. But otherwise, maintaining your underlying non-immigrant status will be much easier for H's and L's. For B visitors, B1s, B2s, we believe that's the highest risk right now and should be evaluated carefully and risks understood before filing an adjustment of status from a visitor status at this point. And, also keep in mind that some family members have different statuses. One spouse might be an H and another an F. And so everybody's going to need to analyze their individual statuses. And if the primary applicant F1 travels, their F2 will lose their F1 status based on the primary applicant traveling, where that's not true if the dependent travels. So each family member is going to have to make sure to think through their own status very carefully.
Awesome. All right. Joel, this is our last question. It's our 10th. How does this guidance affect investors from countries where the State Department has paused all visa issuances already? 75 countries or so.
Right. So yeah, 75 countries back in January, I think it was. I think the first critical thing to realize is first, obviously, this only affects the 75 countries. This was primarily a concern about individuals coming in and being a public charge, being on welfare. So it only affects those 75 countries. And it was notably a pause. So you can still go through the process of consular processing if you're from these countries, if your nationality is from these countries. You can file your paperwork, you can go through the interview. They're still scheduling interviews according to USCIS. You can get up until that last step, and then the pause kicks in and the visa would not issue. So at this point, it depends on obviously the timing of your individual case and where things fall. And obviously there's a hope that this pause at some point gets lifted along your individual process and that the timing aligns. Obviously, we don't have any insight or really estimates right now as to when that pause gets lifted.
Yep. Well, all right. Okay. So that hopefully has shed some light and provided some clarity about what we think we know and what we won't know until we have some adjudications implementing this memo. So I think I'm going to call it a wrap. Should we try to, there are quite a few questions.
I really think that in a generic way, we've hit on the responses to all of these questions without going into too much detail of a particular status or particular question. But there were two questions that I think might be worth addressing. One is, do you anticipate any issues for already approved conditional permanent resident cards when filing for the I-829 to remove conditions? Is this memo going to impact people as they're removing their conditions?
That's a very understandable question.
Yeah,
but
which is probably too soon to know, but
Yes, yes, that is very correct. But keep in mind, you know, because of the language in the memo, I think it does invite like what else, right? The question,
Right.
what else? And but this is about adjustments under INA 245. Removal of conditions is under INA 216, a completely different section. I do think that this may lay the groundwork for related discretionary benefits, in particular, the grant of advanced paroles, as an example. So I think all the adjudications related to the 485, to the AOS, we need to be very, very careful about and monitor closely. 216 is the removal of conditions. I think we could see some restrictions, some, additional movements there arising from the more sort of, the ambient environment of heightened restrictions generally, but on its face, no.
Mhm. And because of um, the prohibition against re-evaluating a prior decision made unless there's fraud or some kind of misrepresentation or mistake of law, the 485 would not be reconsidered at the 829 stage.
Yeah, the one section that in the balancing factors that is a little bit kind of touches on this and could be a little bit concerning is that if there's any future change that could make things a little bit, I mean, in the way that the express language is, if it ameliorates the situation, but at the time it was still no good, then that can be a negative factor. So I suppose it could be spun out such that maybe this memo gets revoked or some aspects of it get, redone to be more expansive. But then, if there were some factors, negative factors that were triggered while the memo was still around, could that be used in later adjustment of status adjudication? I would think not logically, just, carrying out that particular scenario, but yes, there's hard to know for sure.
Yeah. Wonderful. I think that covers our questions.
It's helpful to talk these things through
It is.
and to hear others. So, well, Lindsay and Joel, thank you for your insights and for sharing your thoughts with our audience. And tune in, everyone. Going to be talking a lot about this in the coming months. So take it easy, take care, and we will see you next time. Bye-bye.